Hi, I'm Maggie Leone, the Human Resource Generalist here at CrossPoint Clinical Services. And what this presentation is today is I am going to briefly touch on all of our policies and our employee handbook. So you can find all of our policies as well as our employee handbook in Checkwriters. So when you log on to Checkwriters, on the left-hand side, you'll see a menu, and on that menu it will say My Documents. So what every person needs to do is go into My Documents, read the policy, and then at the top it will say My Signature and just sign off on it. So what this presentation is, I'm going to give a brief explanation of every single policy. And if you have any questions on any policy or need any assistance, I'm definitely always available. So the employee handbook is definitely a valuable communication tool. And what it contains is information on CrossPoint Clinical Services history, our mission statement, and what our values are. Also, it has information related to policies, procedures, and benefits. So whenever you have a question about anything, any benefit or any policy or really anything that you may be wondering, most likely it will be contained in the employee handbook. So you can just refer to that and see if it answers your question, and if it does not, of course, you can always call me. The first policy that we are going to discuss is called the American with Disabilities Act. So what this law does is it requires employers to reasonably accommodate qualified individuals with disabilities. A qualified individual means a person with a disability who, with or without a reasonable accommodation, can perform the essential functions of the job. So in all work environments, an accommodation is considered anything that allows someone to do the essential functions of the job. Determining whether an accommodation is reasonable or unreasonable is an interactive process. Typically, the employee starts the process by coming to the employer with a request, and then the company and employee work together to determine the reasonable accommodation they will need to complete their job duties. As part of that process, the accommodation will be determined whether it is temporary or whether the accommodation is permanent. This is an important step, as often temporary accommodations are reasonable because they will be met by an employer on a short-term basis with minimal hardship to the business. If the accommodation is determined to be permanent, there is more likely to be a cause that the accommodation is unreasonable. Ultimately, a doctor makes the determination if an accommodation needs to be made permanent or temporary. So the reasonable accommodation, it can't be an undue hardship on a company. So for example, say somebody was hired to do data entry and they come to their employer and say, listen, I can't type more than 30% of the day. So you really need to hire someone to do 70% of my work. So that would be something that wouldn't be a reasonable accommodation because it would provide an undue hardship on the company. So the next policy we're going to discuss is the background record check policy. So all offers of employment at CrossPoint Clinical Services are contingent upon clear results of a thorough background record check. Background record checks will be conducted on all prospective employees and on all current employees. And so, and we need to recheck like the query and the SORI every 3 years. So The background record checks, like it says in the screen, includes queries, which are criminal offenders' record information. And if someone has hits on their query, they just have to go through what's called a discretionary review, which is just to discuss what's on their query, and the person would just have to give an explanation of each charge on the query. The SORI is sexual offender record information, so we as well check that. We always check 3 professional references before somebody is offered employment, and we also make sure that their license is current and valid. The next policy that we're going to discuss is the Computer and Electronic Media Policy. So all email, internet access, and other electronic communications are tools that are provided solely as business tools by CrossPoint Clinical Services. So all communications inside and outside of CrossPoint Clinical Services should be professional, and it should be appropriate. So in using computers and other electronic devices, internet or email systems or other communication systems in ways that are disruptive, offensive, or harmful to morale, disrespects, defames, or slanders others is specifically prohibited. Employees' passwords are confidential. So you just don't want to do things like write your password like on a sticky and then stick it on your computer. You definitely probably have to write down your passwords. I know I do, but you just want to make sure that you put it on something that is hidden, that somebody can't find it. And also, employees should not open emails unless they are confident of the sender. And this is happening more and more recently. We've been getting emails from people posing as employees, and they're not employees, they're scams. So be very aware of that, and just be very confident of the sender. And finally, CrossPoint Clinical Services reserves the right to review, audit, intercepts, or disclose messages or materials created, received, or sent over the company's email or internet systems. Next, we're going to talk about confidentiality policy, which is similar to our HIPAA policy, but it goes beyond just protective health information. So there's more to our confidentiality policy than just like medical information. So employees may not disclose confidential information outside of CrossPoint Clinical Services. So, I mean, it can mean things like, of course, client information, that's for sure. But also for me, it's like employee information or billing information or marketing information or anything that we consider confidential. And someone should not seek to disseminate information without a need to know. So if someone doesn't need to know something, then they shouldn't look to know it, or somebody shouldn't tell someone that they don't need something that they don't need to know. And I'll give you an example of that. Like I have access to everybody's personnel files, so I don't randomly flip through people's personnel file unless I have a specific need to know something in the file. Also, conversations, make sure that if you're having a confidential information, that it's somewhere in like a secure location where someone can't overhear what you're saying. So you don't want to have a conversation like in the reception area. You want to make sure that it's like in a room with the door shut where someone can't accidentally overhear what you're saying. So now we're going to discuss HIPAA. Now, HIPAA is training that's required for all new employees, and also it should be an annual training just to refresh people's memory on what HIPAA is and how important it is as a federal law. So, and I'm sure it's been around since, like, I think 1996. So it is something that I'm sure many of you are very familiar with, and you probably sat through quite a few trainings like I have. So, so the part of HIPAA that we really are concerned about is called the privacy rule. So as employees, you need to know how to be sure that your client's health information is confidential and safeguarded. So when you talk about HIPAA, it's more than client information. Like for me, it's employee information too. So safeguarding protective health information is required under HIPAA. So obviously many employees at CrossPoint Clinical Services have direct access to patient information and a legal and ethical obligation to protect your client's privacy. So PHI includes any client health information that is individually identifiable. So to get more deep into what PHI is, protective health information is, it relates to the physical or mental health of an individual, and it can be at any time, so it can be past, present, or future. The identifiers can be used to identify individuals. So identifiers are things like someone's name, address, social security number, date of birth, things like that. So sometimes, like, even if you take someone's name away from something, that person can still be identified. So if you're trying to de-identify someone, you want to make sure you take away all the identifiers. Health information that is electronic in paper form or spoken in conversation among clinicians, medical information, and medical records is also considered protective health information. So PHI can be used or disclosed with or without certain authorization. So HIPAA privacy rule gives employees and clients rights over how their health information may be disclosed, and protects the unauthorized disclosure of medical information known as, of course, PHI, protective health information. So the HIPAA privacy rule requires covered entities to handle PHI very cautiously. So it does establish limitations on who can view and receive health information, whether it's in electronic, written, or oral form. So sometimes the client has no control over who has a disclosure of your PHI, such as, for example, billing purposes. So the U.S. Department of Health and Human Services are the ones that enforce the HIPAA rule, privacy rule. Next, we're going to discuss the Parental Leave Policy. Parental leave is a Massachusetts law, so it requires employees to provide 8 weeks of unpaid leave for the birth and adoption of a child. So this leave does run concurrently with paid family medical leave, but they are two different laws. Parental leave and paid family medical leave are two separate laws, but they run concurrently. Parental leave is unpaid. Paid family medical leave is paid. But we're discussing right now is the parental leave, which is unpaid. So the parental leave, in order to be eligible for it, you do have to pass your initial 90 days probationary period. And there is some medical paperwork that is required. So an employee is entitled under this law to continue group benefit coverage. So if someone is on our medical plan or dental plan, then they can continue with the plan, but they're just going to owe whatever deductions. They're not because they're not receiving a paycheck, it won't be deducted from their paycheck. So whatever that deduction is that's not being paid, the person is still responsible for the deduction when not receiving a check. So now we're going to talk about paid family medical leave, or PFML. So PFML is a very new Massachusetts law, and what it does, it provides 20 weeks of paid leave that is available for employees for their own serious health condition. So that part of the law has been around since January 1st of 2021. And effective July 1st, 2021 is the family leave, and that provides 12 weeks that's available if one of your family members, eligible family members I should say, needs your care. So it can be your kids, it can be your parents, grandparents, in-laws, siblings. And this leave law is administered through a brand new department called the Department of Family and Medical Leave. So if you need this leave for your own serious health condition or for a qualified family member, then that's how you would apply for it. You would apply online through the Department of Family and Medical Leave, and they will require you to get documentation from, if it's for your own serious health condition, then you're going to have to provide them with documentation from your doctor, and if it's for a family member, then it will be documentation from their doctor, and the department is the one that decides whether you're eligible or not CrossPoint Clinical Services. But we do want to know that you're going to be applying for this leave, so we would like you to at least 30 days notice if you're going to if you know that you're going to need to be taking this leave. And also, employees that are returning from leave will be restored to their previous position or an equivalent position. And if you have any questions on this leave, because it's not so brand new and people aren't very familiar with it, give me a call. Or you could also just look at our policy, but it's probably easier just to give me a call. Okay. So CrossPoint Clinical does offer a paid time off policy, or PTO. So we realize that work-life balance is essential to maintain quality performance in a positive work environment. So basically how it works is that all employees get an equivalent of 20 days if they're a full-time employee. So if you're a full-time employee and you're salaried, so it means you're exempt, then you're going to receive PTO January 1st. So basically what that means is that you're going to get a lump sum on January 1st. So if you're not exempt or you're not a salaried employee, but you may be a fee-for-service or hourly employee, then what happens is that you accrue by the hour. So you don't get the lump sum in the beginning of the year, but every hour that you work, that you'll be accruing time off. So if you ever want to know what your paid time off balance is, just go in Checkwriters and it will tell you. And how do you request time off? You need to request time off in Checkwriters. So you just log into Checkwriters, and then there's a menu there that where you can request time off in Checkwriters. And then once it's approved by your manager, then it will flow right into your timesheet for the week that you're taking off. The Pregnancy Workers Fairness Act policy basically just requires employers to reasonably accommodate employees due to pregnancy or pregnancy-related issues. So say, for example, an employee is pregnant and they need to take more breaks than someone else, then that would be considered a reasonable accommodation. And we also are required to provide a private place where someone can express breast milk if they are breastfeeding, and also a refrigerator in order to refrigerate it. So if you happen to need a pregnancy related accommodation, you can definitely contact me. So as you probably know, we do have a referral bonus policy. So we are always looking for good licensed clinicians to work here at CrossPoint Clinical Services. So if you know someone and they do get hired, we do give you a bonus. So if you refer someone and we hire them, you will receive $500 for if they're fee for service and part-time, and most likely they will start off that way anyways. In the event they become full-time, then you'll get another $500, which equals $1,000. So, and I'm going to need to know that. So attached to the referral bonus policy, there's something called a candidate referral form. So if you would just fill out that form and let me know that you referred somebody, then you would get that referral bonus. We do have a return to work policy, and this applies only to full-time salaried clinicians. So what this policy does, it assists clinicians who return to work from a leave of absence for family or medical reasons. So CrossPoint Clinical Service has established a gradual schedule to return a clinician to full productivity. So it's very beneficial for the clinician coming back to work because it eases them into full productivity. So how it works is that the first pay period, the clinician only has to meet 50% of their productivity. So, but they do get their full pay and full benefits. The second pay period that they come back from leave, then they only have to meet 75% of their productivity, and they'll get their full pay and benefits. And then the next pay period, they're going to have to meet their full productivity. The next policy is sexual and other unlawful harassment, which is required training when someone is first hired at CrossPoint Clinical Service, and every year we're going to require people to sign the policy again and have a refresher in the training, the online training. It is something that is strongly encouraged by law that we do refresh every employee every single year, because CrossPoint Clinical Services is committed to providing a work environment free of harassment in any form because of their inclusion in a protected class. So what a protected class is, just in case you don't know, in Massachusetts it's considered someone's sex, age, so age is over 40, race, color, national origin, religion, handicap, sex, as well as gender identity and sexual orientation. So a definition, the legal definition of sexual harassment is sexual advances, requests for sexual favors, and other verbal, physical conduct of a sexual nature. Submission to or rejection of such advances, requests, or conducts made either explicitly or implicitly a term or condition of employment on a basis for employment decisions, or such advances, requests, or comments have the purpose of unreasonably interfering with someone's job performance by creating like an intimidating, hostile, humiliating, or sexually offensive work environment. So that's the legal definition of sexual harassment. There are two types of sexual harassment. There's a quid pro quo, which is a Latin term that means something for something. So that's someone with more power sexually harassing someone with less power. So it's like a stereotypical someone saying that if you go out with me, then I'll give you a raise or promotion, something like that. The other form is called the hostile work environment, which is usually people that share power. So it's usually a coworker type thing. But in order for it to rise to the level of being a sexual harassment, it has to be something that, like I just read the definition, has to unreasonably interfere with someone's job performance. So sometimes it's usually not a one-time thing. It's something that's repetitive, something that happens over and over. So those are the two forms of sexual harassment. In the hostile work environment, just people misunderstand what that means. An illegal hostile work environment is that you're being harassed because of what I mentioned before about protected class. So if you're being harassed because of your race or your sex or your religion or handicap status, any of those things that I mentioned, then that is an illegal form of sexual of a hostile work environment form of sexual harassment. Now, people think that, like, for example, if someone's boss is just like not a nice person and their management style might not be that professional and they might yell or something like that. Now that is not an illegal form of a hostile work environment, because unless they're harassing you based on one of those protective characters. But if that's the way they are, their personality, even though it's unprofessional and it can be handled or it can be remedied in some other way, it's not considered an illegal form of a hostile work environment. Now, retaliation is illegal. So if someone, like, I'll give you an example. Say your boss says to you, you have to sleep with me or you're fired. And you go and you tell the HR department and your boss finds out and they fire you. Well, that's not something that they can do, because that would be considered a retaliation, and that's illegal. So retaliation can be termination, a transfer from a position, like or your boss is like denying your vacation request, things like that. That's considered retaliatory and is illegal. So anytime someone complains about anything, it's protected by this no retaliation law. So when somebody complains of sexual harassment, now the complaint process is you can actually, if you want to, the first step is, if you think that the person is doing it ignorantly or you feel like you can remedy the situation yourself, you can go to that person that is harassing you and tell them to stop, that their conduct is offending you. And then and that could be a good first step. But I mean, if that person doesn't respond or you don't feel comfortable doing that, then you can always go to your manager, and there's always the HR department that you can come to. So just so you know, whenever there's a complaint of sexual harassment, it is immediately investigated. It is confidential as possible, but it can be completely confidential only because of the investigation. There has to be, the person that's the alleged harasser has to be interviewed, and anybody that may be a witness, but it is kept to that group. So I mean, if anybody spreads anything about it, then that's a disciplinary action. And so based upon whatever is the outcome of that investigation, there will be disciplinary action and it depends on, the circumstances. So it could be something like a warning or a termination. So the next policy is the social media policy. So obviously outside of work, you have the right to free speech and the right to maintain a social media account or whatever that may be. So all this policy is doing is just to remind you that the use of social media follow the same standards of practice and conduct outlined in our employee handbook. So what you publish on social media should never be representative that you are speaking on behalf of the company unless you have proper authorization. And so employees should not use social media to post or display anything about coworkers, the supervisors, or the company that are discriminatory, threatening, or vulgar, or obscene, or illegal in any way. Our next policy is our telecommuting policy. So telecommuting is obviously much more prevalent now after the COVID or during the COVID pandemic. However, not all jobs are suitable for telecommuting. So telecommuting may be appropriate for some employees and jobs and not others. So for example, if someone works in a restaurant or hospitality industry, then obviously they can't work from home. But if you're a clinician, then that may be a possibility. So either an employee or a manager can suggest telecommuting. What the employee and manager will do is assess the suitabilities and make sure that the employee is the right fit. Make sure the job is the right fit. Make sure that there's tools in place, communication in place, and things like that. Telecommuting employees may be expected to ensure the protection of company and client information. So if you are a clinician working at home, you want to make sure that you're just not leaving client information laying around, or people can overhear your sessions, or someone has access to your computer, things like that. Workers' compensation policy. So it is the responsibility of each employee that all tasks are conducted in a safe and efficient manner to avoid any workplace injury. Please communicate with your supervisor regarding any safety issues or concerns that you may have. If someone does get hurt on the job, please make sure that all workplace injuries are reported within 24 hours of the occurrence, because it's very time sensitive. If somebody gets hurt at work, we want to make sure that your injury is covered by workman's comp. So it's a time sensitive that we get a first report of injury form filled out and completed, so I can send it to our workman's comp carrier within 24 hours of the incident. And just be aware that even if somebody gets hurt and say that person doesn't feel the need to go get medical attention, but they still should fill out a first report of injury form just in case, say a month from the injury, something starts to really hurt or it's worse than initially thought, then it will be covered by workman's compensation if there's that initial first report of injury. So that's really important. Workplace violence policy. So CrossPoint Clinical Services believe that all employees should be treated with dignity and respect. So employees are prohibited from making threats or engaging in violent activities. So if anybody suspects any dangerous situation, they should be reported to either their supervisor or the Human Resources Department. Last but not least, we're going to discuss workplace behavior standards of conduct policy. So it is the policy of CrossPoint Clinical Services that employees maintain relationships that encourage mutual respect, promote civil and pleasant working relationships among employees and is free from all forms of harassment and violence. CrossPoint Clinical Services has certain expectations of behavior and conduct at work. Employees are expected to always conduct themselves in an appropriate and professional manner. So, in our workplace behavior and standards of conduct policy, it does have some guidelines that I encourage you to look over. I mean, it would take 20 minutes to read them all to you, but it's basically a list of examples of unacceptable conduct. That is, but it's not an exhaustive list, but it is examples. So it is a duty of every employee to be aware and abide by these existing work rules and policies. And we also have a progressive discipline process that addresses issues such as poor work performance, misconduct, policy violations, to encourage employees to become more productive. So in conclusion, please remember to refer to the specific policy and our employee handbook to get more clarity on each policy. And also remember that I'm always around and available. You can send me an email or call me or stop by, whatever is more convenient for you, for any questions that you may have or any help that you need. Okay, thank you.